Good morning, everybody, and I apologize for the delay. We are here today to hear our guest speaker, Angel Yang Riley, Esquire. The topic is 5 myths about estate planning. Angel's an associate attorney at Chauvel Glatt, LLP, and we are the San Mateo Area Chamber of Commerce presenting this Business Essentials today. And my name is Pauline Chung, Director of Communications, and I'll let Angel take it away. Thank you, Angel.
Thank you, Pauline. Good morning, everyone. Thank you so much for joining me. I see quite a few familiar faces and some with no faces because you're working from home. So you're probably, in your pajamas still, but that's okay. Thank you so much for joining me. So our topic today is 5 myths about estate planning. And I decided on this topic because quite often, I get what we call cold calls from potential clients on the phone. And one of the first things they say to me is it true that I don't need, or is it true that if I'm married, and usually the answer is no, or it depends, because again, they go on the internet and very much like LegalZoom, yes, the information isn't always wrong, but it's a very general coverage, and most family members or most families have some kind of require more detailed planning in order to complete their estate plan. So I thought today I would cover some of the most common misconceptions and some of the myths that I hear when I receive these cold calls. So what I'll do is I'm going to screen share our PowerPoint. Okay. So, oops. Okay. So here we are, 5 myths about
Angel.
Yes.
Angel, you have a double screen shared. Could you go to the top where it says display properties? Drop down, it says on the left hand side.
Display.
Yeah,
oh.
Right there. Drop that and you said duplicate.
Yes.
Click that, please.
Is that better?
There you go. You're good.
Okay, thank you. Okay, so before I get started, I do have to read this for everyone that's a part of this chat. And it's a disclaimer regarding our discussions today. And it says, no information presented in this presentation constitutes legal advice, nor is it intended to be fact specific, as there may be occasions where Angel Riley or Chauvel Glatt represents clients who may be adverse to your interests, discussion, questions, or any program content related to this webinar cannot touch upon any fact-specific matters. Attendees should consult knowledgeable legal counsel to determine how applicable laws pertain to specific facts and situations. Also, be further advised that these materials are based on most current information available. Since it is possible laws or other circumstances may have changed since this presentation, please consult with legal counsel to discuss any action you may be considering as a result of attending this webinar. Attendance at this program and or receipt of these materials is not intended to create, nor does it establish an attorney-client relationship. All right, so today, again, 5 myths that I often hear about estate planning, how these myths can harm you, and what you can do to start your estate plan. Okay. Myth number 1, a will is all I need to protect my assets. So not always, and the reason why is in California, we have a threshold for probate, and the threshold for probate is $166,250. And what that means is if you have assets that are over this amount, even if it's a penny, at the time of your death, that property can be subject to probate, which is a very expensive and time-consuming process. If you have assets that are over that amount, then the only thing to prevent probate is a revocable trust. Okay, the revocable trust allows you to, 1, avoid probate, It allows you to designate beneficiaries as well as contingent beneficiaries over your estate plan. So very often what that means is if you want to give everything to, let's say, your children at your death, well, then the contingent beneficiary would be, what if one of your child, God forbid, predeceases you? Then what happens to that child's share? These are the language and contingencies that really wouldn't be in place unless you had a revocable trust that clearly memorialized your wishes. In addition, you get to select trustees over your trust assets, right? So then that means if you have, let's say, a home inside your trust, who's going to manage your home and who's going to manage your assets to, let's say, utilize, take care of your child until maybe your child reaches the age of 25 or 30. Okay, so those are all the very important components that a trust can do. And again, the lesson here is that a will is not the dominating document that is going to help you avoid probate. Number 2, I only have a modest estate and therefore I do not need an estate plan. Okay, so modest estate in the Bay Area is kind of it's a gray area, right? Because sometimes I get calls from someone that, let's say, bought a home in Berkeley 40 years ago for, let's just say, $60,000. So in their mind, they think, okay, I live in this home that I bought for X amount, and today I don't really know how much it's worth, but I assume that my estate is modest. Well, if you remember from my previous slide, the threshold for probate is about $166,000. In my example, that home in Berkeley more than likely is at least worth $500,000 today. And so that individual who thinks they have an immodest estate, as far as we're concerned and the eligibility to get you in a probate, the answer is no, you don't have a modest estate. Okay. Even if you did have a modest estate, which in my definition would be, let's say, you have $50,000 to your name at the time of your death, sometimes we can administer that estate through what's called the California Small Estate Affidavit. But even then, there are some restrictions with that, and I think I have that on the next slide. Okay, now let's move away from your assumption that you have a modest estate. What about minor children, right? If you have minor children, you still need to think about your estate plan in order to designate guardians over your minor child or minor children. And same thing with powers of attorney for healthcare and property. In the event of an individual's incapacity, a bank and certainly a doctor are going to need powers of attorney in order to designate agents to make decisions for you. Okay? And those documents have nothing to do with the trust, but they're still estate. They're still part of estate planning and planning your estate so that your affairs are in order. Okay. And number 3, I'm too young to worry about estate planning. That's not true unless you're under the age of 18. A few years ago, our firm started to implement this grad special, which we would run usually around spring, summertime, where we allow parents to bring in their children who've just maybe turned 18 or maybe are during a leap year before they go into college, or maybe they're back from college for spring break or summer break. And the reason why we do that is because we want to communicate to these parents the importance of having a power of attorney for property and healthcare for their children, even if their assets are at a negative, let's say because of student debt, right? And the reality is your child, as soon as he or she turns the age of 18, they need powers of attorney for healthcare and property. Because if something happens to that child, God forbid, again, financial aid, the school nurse, doctors, their bank, they're going to need those documents in order to allow the parents to make decisions for them. So when I hear this comment, I'm too young to worry about estate planning, I don't have any assets. Well, maybe you don't have much to your name, but at the end of the day, powers of attorney for healthcare and property is still very important, and it should be done at a minimum in order to, again, have all your affairs in order. Okay. And this fourth one, I hear pretty often as well, and that's, I'm married and everything will go to my spouse, and so I don't need an estate plan because that's what's going to happen. Yes, being married and having a home or even your assets as joint accounts, or your home held as community property with right of survivorship, that definitely makes the administration easier at the time of the first death. But it gets incredibly complicated when there are blended families in the situation. And what that means is, you know, both spouses had previous marriages. And from those previous marriages, there were children. And so now you have stepchildren in the situation. And so generally speaking, if you have community property at the time of the first spouse's death, usually the surviving spouse inherits the community asset. So if you have a home that's a community property, usually that goes completely to the surviving spouse. However, if you have separate property, that's a whole different scale. And if you have separate property, the surviving spouse can get up to half of the deceased spouse's separate property. This is if the deceased spouse has children. And if there's more than one children, that number and that fraction changes. Okay. Not only that, nowadays we have different family situations where we have children that's adopted or children that's stepchildren. Those two different kinds of categories involve different laws in terms of the probate code. And so if you have families or you have that in your life, it's incredibly important to think about estate planning and not assume that everybody will be taken care of at your death. Okay. Similarly, now we have, you know, situations where people are having children without getting married. Well, the way the probate code views children, there's actually a difference between children that are born inside of a marriage and children that are born outside of a marriage. So these are things that, you know, a lay person usually won't consider, but they do matter when it comes to your estate plan. Okay. Okay, and myth number 5 is I do not need to review my estate plan. That's also not true. As a general rule, it's wise to review your estate plan at least every 2 years. And if you really forget, then at least every 4 years. The reason why I say 4 years at max is because in theory, every 4 years, we can elect a new president. And so in that 4-year time, depending on who's in office, that person can change tax laws. And so if those tax laws are changed in a way to affect your estate plan, it's important then to take that out and review it. Okay. Also, if you review your estate plan every 2 to 4 years, you have a chance to make sure that your beneficiary designation is still in accordance to your wishes. Your successor trustees remain qualified to manage your assets. Same thing with guardians. Your guardians remain qualified and the best people to elect to take care of your minor children. That all of your assets are properly funded into your trust. And also that your estate plan is up to date to reflect any changes in particularly tax laws. Okay, so if you have an estate plan, you should take it out every 4 years, take a look at it. Okay. Other reasons to review your estate plan, obviously, if there's legal separation or divorce, if you've had more children, if you've bought more property. One of the common mistakes that I see, you know, and not to the client's fault, it's just life, is what happens to a real property in the event of a refinance. So I personally recently refinanced, and what the lender made me do is, you know, I had my property in my trust. They made me take it out of the trust, refinance in my own name, and then thereafter place it back into the trust. What I've seen on more than one occasion is that individuals refinance, they take it out of the trust, refinance in their own name, and unfortunately forget then to put it back in their trust. 30, 40 years goes by, that individual or maybe the spouses both die, and the children come to me and I look at the deed and I realize, oh my God, this home that's worth 1 million or whatever was never properly or was never funded back into the trust. Well, if your property is not properly funded into the trust, thereby, under the shelter of the revocable trust umbrella, then that particular property is subject to probate, right? And of course, that was never the intent of the individuals that, only wanted to refinance some years ago. Okay, so very important to, take your estate plan out and just take a look at it. If everything looks fine, great. But if there are changes, you want to make sure you fix those when you can. Okay. All right, and a general summary. So a living trust shelters your assets and avoids probate. A will is not enough for you to avoid a probate. Having a modest estate does not mean you do not need an estate plan. Even 18-year-olds need to consider estate planning. Estate planning is very important for blended families. Okay, and you should review your estate plan once every 2 years. Okay. And with that, I'll end with the disclaimer and open up the floor to any questions.
Yeah, there are no questions in the chat, but you can unmute and ask your question of Angel.
Hey, Angel, this is Dinakar again. And one particular question with respect to the previous slide or the last slide where you said you take out an asset of the estate and then whatever refinancing you do and you put it back. In that situation, do you have to, or as a lawyer, you rewrite the estate plan and then you submit it back to the authorities and you have to do that twice? Is that how it works?
No. So when you refinance in that particular scenario, the lender usually prepares the deed to transfer the home out of your trust. So it'd be like, Jane Smith, trustee of Jane Smith Trust to Jane Smith. So they're literally pulling it out of a trust, and then you finish the refinance. And most responsible lenders will prepare another deed to transfer the home back into the trust, which is just Jane Smith to Jane Smith, trustee of Jane Smith Trust. Sometimes though, and this is what I've seen, is somebody drops the ball, and then years go by and we realize this property is unfortunately not sheltered in the trust.
That makes sense. Thank you very much. Appreciate it.
And are there any other questions?
Angel, I have one. Is a revocable trust, a living trust, the same thing?
Yes. Revocable, living, family trust, yes.
Okay.
Anyone
I have
else?
a question for you, Angel.
Great.
Yeah.
Can you talk about, you mentioned that you need to know about all the assets, including IRAs and so forth. How do you normally recommend naming IRAs or beneficiaries of IRAs? You still name the individuals so that you can stretch out the taxes when the person dies, or do you recommend naming the trust as beneficiary for control, particularly for minors? Or can you talk about that a little bit?
Yeah. That's a really good question. So early on, I said, in response to, I think, another question is, for me as the planner, I would need a list of all your assets, which would include, as you mentioned, the IRA, 401k, life insurance. So I say that primarily because, if your children or your beneficiaries come to me at the time of your death and they say, okay, what did mom and dad or what did whoever own? My answer should not be, I don't know, right? My answer should be, this is what I have, and this is what I had as of blank date the last time we communicated. Now, in terms of funding your trust, your home goes into your trust. Your CD accounts goes into your trust. Your money market account, that goes into your trust. Same thing with stock accounts, bank accounts, all that should be properly funded into your trust. Your IRA, your 401k, your life insurance, those accounts have beneficiary designations. Particularly for 401k and IRA, there are tax implications for you to transfer or for you to name a trust as a primary beneficiary, because the IRS considers a trust as a thing, right? A trust is not a person. So for 401k and IRA, if you have a spouse, your spouse should be the primary beneficiary. If you have adult kids, then I would recommend naming them as a secondary beneficiary. The times where, let's say, my client is a single parent and let's say everything they have is in their IRA account and their child is 5 years old. Well, obviously they can't name a 5-year-old as a beneficiary of an IRA account, right? And so in those situations, we have what's called an IRA trust, which we can create. And that particular trust has language specifically for the trustee to follow in order to take advantage of the tax benefits that are implied in IRA and 401k accounts. If you do not have an IRA trust, I don't recommend, and your CPA and your financial advisor too would probably not recommend you naming a trust as a beneficiary, because that can subject you to tax consequences at the time of death. Does that make sense?
Yep, great. Thank you very much.
So Angel, what types of assets should not be put in a trust?
So normally it's 401k accounts, IRA accounts, life insurance, and let's say pensions that end at death, because that's just moot. If it ends at death, there's no point. And I would say personal property, and that just makes sense. Like, for example, you're not going to go around your house and inventory how many lamps you have and couches. You should for insurance purposes, but nobody ever, I don't know anyone that has. And so those particular personal properties you usually don't have to put into your trust.
Okay.
Okay, Angel, this is Pauline. I have a question from Annabelle in the chat. She says, my mom created a trust but never designated beneficiaries. Will this have to go to probate when she passes?
The short answer is yes, because if there's no beneficiaries, then the law doesn't assume that she meant to give it to so-and-so, even if those individuals are, let's say, blood relatives like yourself. Whoever, and also the important thing is, was the trust properly funded with assets? Because if it was not, then basically the trust is just a piece of paper that, based on what you're saying, is incomplete and doesn't shelter any assets. And so there's a couple layers here. But either way, my gut instinct and the short answer is that yes, somebody will have to take this up to a probate judge and basically say, judge, this person signed this trust. We don't have any beneficiaries. This is what we think this person may have wanted, or something to that effect. And the judge ultimately has to make a decision.
Okay, thank you. Any other questions for Angel today?
Thank you, Angel.
Thank you.
Okay, if not, we'll wrap up. Thank you so much, Angel.
You're very
Yeah.
welcome.
Thank you.
Thank you.
This is recorded, so I'll get it posted on YouTube. Then we have 2 more business essentials this week. Tomorrow we hear from Richard Price. His topic is get a grip on your business. Crisis. Are you running your business or is it running you? So he's a process strategist to help you have a more successful business. And on Thursday, we hear from Mark Allen. He's the president of City Publications, but I've asked him to give us tips on using Google. So Google Drive, Google Sheets, how to set up a simple Google form. So it's visiting the Google world with Mark Allen on Thursday at 10 o'clock. Friday, we have a town hall meeting. For those of you interested in or utilizing the PPP loans, they have updates on how to apply for the forgiveness. Okay, question in the chat box, can you send out the YouTube link? Yeah, as long as you're registered I will send out a follow-up to this event, and it will have the link to the YouTube and any handouts that Angel might have. So that's the importance of registration, not to just get you into the meeting, but any follow-up information I send out to the registered people as well.
Pauline, thanks for keeping the bad guys out.
Yeah, I was
Yes,
so
thank you.
afraid today.
Thank you. And thank you everyone for taking the time out of your day to join me. The weather is nice, so hopefully you get some sun today. And any questions you have, feel free to give me a call or shoot me an email. When Pauline sends out the PowerPoint, my email and contact information is on there. So I look forward to anyone that wants to chat more about estate planning.
Thank you. Have a great day, everybody. Bye.
Thank
Bye.
you. Take care.
Bye.